Greetings. Today is our first class on criminal procedure. Criminal procedure can be organized into two main categories, two big categories. And those two big categories are what happens outside of the court system and what happens inside the court system. Outside the court system, it's basically the police or some state representative, but primarily the police, who do things. Inside the court system, you have several people who do things. You have the judge, the jury, the prosecuting attorney, and the defense attorney. Outside the court system, it's the police who can violate the Constitution. Inside the court system, it's these four people who can violate the Constitution. So what we want to do is to look at what the police do, and therefore what parts of the Constitution they might violate, and secondly, inside the court system, what each of the other four people in the court system do and how they might violate the Constitution, and some examples from the problems which have been on the bar exam. We begin by looking outside the court system. If we look outside the court system, outside the court is basically the police. So if we look at the conduct of the police, what do police do? What police do is they search and seize. The police interrogate, they obtain information, search and seize, they obtain information. That is, they interrogate people, they get confessions, that sort of thing. And thirdly, they identify. In the course of searching and seizing, what kinds of constitutional issues do we have that occur in that setting? And the answer is that, first of all, there is the Fourth Amendment. The Fourth Amendment prohibits unreasonable searches and seizures. The police also, besides searching and seizing, that's the main thing that they actually do under the Fourth Amendment. There is also a due process argument you can make. Not a real strong due process argument, but we can make one. Let's do it this way. There's the 14th Amendment. Let's do that next. And there is the Fifth Amendment. The 14th Amendment says that I'm trying to find my pointer. Sorry, I'm looking around here and can't find it. Okay, we're back in business. The Fourth Amendment prohibits unreasonable searches and seizures. The 14th Amendment says that the Fourth Amendment applies to the states through the Due Process Clause of the 14th Amendment, and the Fifth Amendment Due Process Clause has its own Due Process Clause, it's possible to search or seize in such a way that it violates due process. It doesn't happen that often, but it's these two main ones. Under the Fourth Amendment, the basic rule is that it prohibits unreasonable searches and seizures. So the question is, what is an unreasonable search and seizure? Well, the basic starting place is get a warrant. police want to search, you get a warrant. That's the starting place. If the police did not get a warrant, then the requirement is that the police or the state has to prove that what they did qualifies under warrant exception. So you get a warrant or prove a warrant exception. And the state has a burden of proof, and the standard is preponderance of the evidence. Preponderance. So get a warrant or prove a warrant exception with a preponderance of the evidence, and the state has the burden of proof. So the problem here is, what are the warrant exceptions? And there's a bunch of them. And the bar exam questions, of course, are almost always addressed to these warrant exceptions. Warrant exceptions, so also the question also here is, what does it take to get a warrant? So the requirements for a warrant, so you have to know those. And then, what are the warrant exceptions? Well, one warrant exception is if the search is incident to lawful arrest, incident to lawful arrest, that's one exception. Another is the automobile exception. Another exception is probable cause but no time to get a warrant. Probable cause plus exigent circumstances. Probable cause plus exigent circumstances. Another exception is a good faith exception. Another exception is the inevitable discovery. We have a bunch of these warrant exceptions. You can classify them in such a way that you get a few more, but that's the bulk of them there. There's one more that may be of some importance, and that is the public safety exception. Now, and so we need to know the details of each of these exceptions. So under the Fourth Amendment, the basic rule is get a warrant, and there are some requirements for getting a warrant. Be sure you know those. Secondly, if the police don't get a warrant, they have to prove the warrant exception. Here they are here, and you can think of one or two more maybe. 14th Amendment, don't forget to mention in your answer to the bar examiners that the Fourth Amendment, originally was applied to the federal government only, and it got applied to the states through the Due Process Clause of the 14th Amendment. So be sure to put that in there. Just the Due Process Clause of the 14th Amendment got applied. And the Fifth Amendment is the amendment that says the government shall not should not take life, liberty, or property without due process. Well, this is a due process clause also, but this is a more general due process clause. We really are unlikely to find an application of the Fifth Amendment here, but maybe we'll keep in mind. Search and seizure. Next, how do the police obtain information? Well, they obtain information by interrogations, and that's the That's the main way they obtain by interrogations. I don't need two branches here. They obtain it by interrogations. And the place where I need the branches here are if the police interrogate, we've got a Miranda issue. And we have, they interrogate and they get confessions. There are special rules about confessions. Well, what I really want is more of this. With Miranda, with Miranda you may get admissions or confessions, and then due process is what I want here, that the interrogation may be so crude that it violates due process. And if it does violate due process, we've got the same issues again. If you get admissions or confessions, what do you do if it has violated due process? Finally, we identify people. The identification of people, the issue here is basically due process. So if you're going to identify someone, you have to identify them under circumstances where it's basically fair, unfair lineups and that sort of thing. That's what we're talking about here. Basically, what we mean here is fair. Okay, so that is the basic structure of what happens outside the court system. Then, if we turn to what happens inside the court system, let's try to keep this all on the same board so we can see it together. Inside the court system, what I'm going to do is to move this identification up a little bit so I can have just a little bit more room down here to do inside the court system. So here we're going to do IDs, and it's due process, which means fair. And this due process, of course, can come from the Fourth or from the 14th or 5th Amendment. Let me put this on the board. Identification. This can be either the 14th or the 5th. If it is the federal government that violated due process, use the 5th Amendment. If it's the state that violated due process, use the 14th Amendment. And basically, this requires fairness. Now let's look inside the court system. Inside the court system, I have one more that I left off here. This is the 6th Amendment, interrogation, right to counsel. So Miranda, due process, and this is the 6th Amendment, right to counsel. Inside the court system, we have, first of all, the things that the judge might do. And here you might have, the judge might give erroneous jury instructions. The judge might give erroneous rulings on suppression of evidence. That's pretty much it. Then comes the jury. We have jury selection. Besides the jury selection, you can have jury conduct. The chance verdict, flipping coins, that sort of thing. Or the jury might accept information that did not come through the trial process. The jury, for example, might go out to the scene and look at the scene themselves. They're not supposed to do that unless the court takes them out there. Jury selection, jury conduct. The next comes the prosecution. The prosecution can fail to disclose exculpatory evidence. And then finally, the defense counsel can the inadequate ineffective, as we call it. Person is entitled to effective ineffective defense counsel. Violation of the Sixth Amendment. They in effect had no counsel at all. Failing to disclose exculpatory evidence violates due process. Jury selection, we have the equal protection and Sixth Amendment. 14th Amendment, equal protection, and the Sixth Amendment. The Sixth Amendment here says that the person is entitled to a jury of his peers. Jury instructions by the judge, bad rulings by the judge. Jury instructions, incorrect jury instructions might violate due process. The way these can violate due process is when the court gives a jury instruction that in effect invents a new crime. The judge says to the jury, if you find that this defendant did so-and-so, and the so-and-so that the judge lists is not even quite the correct crime because there's a word in there that's been changed, well, that's inventing a brand new crime. And so the judge, it might violate due process by creating a brand new crime. The rulings on the judge on the admissibility of evidence, that might violate the fourth or fifth, if the evidence was seized without a warrant or without qualifying as a warrant exception, if the evidence was seized, then the court itself says, we as a court don't want that information coming into the court system because you shouldn't have seized it anyway. And it's the only sensible way that we can, in effect, enforce the Fourth Amendment. The way we enforce the Fourth Amendment is it used to be that if the police violated the Fourth Amendment and you didn't like it, you could sue them. Well, what good is that going to do? Really, the person's in jail already probably, and it's not an effective way to enforce the Fourth Amendment or Fifth Amendment, any of those amendments. And so the court has said that the way we're going to enforce these amendments is if you seize evidence illegally, then when you come to court, it's just not going to be admissible. So it was the court's device for enforcing those amendments. So these rulings of the court are devices for enforcing people's constitutional rights. And these rulings are really, for a long time, most of these rulings were considered simply discretionary, not discretionary so much as they were the court exercising its own judicial authority to not accept certain types of evidence. And that's how the court started out excluding this stuff, saying we as a court get to control what kind of evidence we want to receive, and we don't want to receive your dirty laundry. And that's how we started with that. But now some of these, like the Miranda, for example, has now actually been interpreted as becoming a part of the Fifth Amendment. For a long time, Miranda wasn't required by the Fifth Amendment. It's simply the court saying this is the way we're going to enforce it. But then later on, the court actually decided that the Miranda ruling was required of the Fifth Amendment. So this basically is how criminal procedure works. Outside of court, search and seizure, obtain information by interrogations. These are the things you have to watch for. Sixth Amendment, Miranda rights, and due process when the police are interrogating, identifying people fairly inside the court, things that the judge, jury, prosecution, and defense attorney might do. Now, with that in mind, as our broad layout of how criminal procedure works, probably the most effective way to proceed from here is for us to look at some questions, and as we look at questions, you see how the details of these get filled out. So let's begin by looking at one of the questions assigned for today, and we begin with a question from the February 2000 bar. That's Sally, Peck, and Donna. Now, in the Sally, Peck, and Donna question, again, I'm going to read the question, and as we come across issues, we'll talk about the rule of law and the application at that time. Of course, I'm not saying that the way you answer these questions is you go through them, and every time you see a fact, you say, oh, this fact raises that issue, and then here's another fact, this fact raises that issue, and so forth. But the bar examiners, depending on how they ask the question, if they ask you, did the government violate the Fourth Amendment, then you say the Fourth Amendment provides so-and-so and so-and-so. You give the Fourth Amendment rule. And then after you've given the Fourth Amendment rule, you begin to look at the facts and say, here, and you apply the facts. So rule application. That's the way the bar examiners want to see it. That's the way you get the highest scores, with rule application. So that's how you answer the question. But as for teaching purposes, when we go through, in order for us to kind of easily stay together, it's easy to go through and identify the issues. In fact, you might actually do this when you take the exam. Identify the issues, but then organize your answer according to what you were asked. So we begin at line 6. Line 6 of the February 2000 question, Sally, Peck, and Donna question, reads as follows. A Picasso sketch was taken from Town Museum by a burglar. The sketch was recognized 3 weeks later when an art dealer in Switzerland read about the theft. The dealer recognized the sketch described in the article as a sketch he had purchased from a young woman with an American accent. Okay, that's all background. Nothing to do there. One of the things that you can watch for here is that when you're doing these criminal procedure questions, if you're outside the court system, it's the cop, or you could have some other state actor, but usually it's the cop. It's the cop that violates the Constitution. So what you do when you're going through these questions is you follow the cop. And everything the cop does, you look for something wrong with it, because that's the only person in the problem who can violate the Constitution out here. And here you look at these 4 people. When you are doing con law questions, of course, the criminal procedure really is con law, just a special branch of con law. But when you're doing general con law questions, it's only the state. By the state, I mean general government. Only the government can violate the Constitution. Individuals can't, except for the 13th Amendment. And so when you're doing a general con law question, you look for the conduct of the government. Since only the government can violate the Constitution, as you read through the question, the first time you see the government did something, that's your first shot at the possibility that the Constitution was violated. So follow the government when you're doing con law questions, follow the cop when you're doing criminal procedure questions. Second paragraph, police, there you have it. The police had been unable to identify the burglar or match fingerprints found at the scene of the theft. Sally is a petty thief with convictions for burglary. Peck, a town police investigator. So Peck is the government. And I usually say that someplace in your answer, that, only the government can violate the Constitution. Peck is the government actor here, and therefore he can violate the Constitution. Here's what he did. Here's the rule, and here's what he did. So be sure someplace in your answer that you connect Peck up to Peck is acting on behalf of the government. And by the way, sometimes that connection between the actor and the government is weak. Now, in the criminal procedure questions, the person acting on behalf of the government is almost always the police. So there's not a weak connection between the police and the government. But what about somebody like a public school teacher? What about somebody who has been commandeered by the police to act as a posse for the police? How about those people who are in that posse? How about somebody who owns the company town and says, at this company town, you people cannot come on the streets of the company town to proselytize for your religious purposes. And so that means that there are no streets because the company owns everything. And so in those cases, the connection between the actor and the government requires some discussion. Requires that you tie them up to show that these people are treated as acting on behalf of the government. What about a person who has a real estate license, and using their real estate license, they sell property and they discriminate against some protected class while selling property? This person got a state license. Are they treated as a state actor? Are they acting on behalf of the government? The answer is no. But you see the point, that there's some line where a person is and is not acting on behalf of the government, and when it's so direct like the police, you can say it in one sentence. When it's less direct, you may need 2 or 3 sentences to explain it. But continuing at line 11, police have been unable to identify the burglar and match the fingerprints found at the scene of the theft. Sally is a petty thief with convictions of burglary. Tech, a town police investigator, believes Sally had knowledge of the theft. Okay? No problem there. He believed that. He can believe it if he wants to. He decided to trick Sally into providing information. Well, you know, police can use a certain amount of trickery if they want to try to get information. They can be honest about or dishonest about stuff. They can say, might be able to say, your co-defendant has already confessed when the co-defendant hasn't. Now be careful, because at some point you may get to the point where the police have violated due process. It'd be an involuntary confession. So, but there's some special rules for that. But what I'm getting at is that the police can use a certain amount of trickery, and they can't go too far. So he decided to trick Sally into providing information. It's in line 13. Continuing, line 14. Tech went to Sally's home. Okay, he's done nothing wrong so far. And he told her he was arresting her for the museum burglary and theft and handcuffed her. Whoa. Okay. He has no probable cause to arrest her. And you know that if he put handcuffs on her, she is arrested. I mean, she is, in other words, the police, if they're going to search or seize, when somebody's got handcuffs on them, they've been seized. There's no question about it. So she's been seized, and now that she's been seized, we look to see, well, was this a lawful seizure? What does it require for a lawful seizure? Answer, to search, it's on the board. To seize people, get a warrant, approve a warrant exception. Well, seizing people normally doesn't require a warrant unless you are seizing them at their home. And then you need a warrant. But if you're seizing them in public, the police simply have to have probable cause to seize the person, and they don't need a warrant because it takes too long to get a warrant. Whereas searching, normally if they're going to search, you need to get a warrant unless you got one of these warrant exceptions. So for the arrest of a person, you sort of always have a warrant exception unless the person is being arrested at their home and it's not hot pursuit. The person is being arrested at their home and it's not hot pursuit, police need to get a warrant. Here Sally is at home. Well, what do you know? And she's being arrested. It says it went to Sally's home, line 14. So she's at home and he arrests her. Well, he's got no warrant. Doesn't even have probable cause to get a warrant. And so that was an unlawful seizure of her. So he didn't get a warrant, doesn't have a warrant exception, because what he did was to seize her. Normally the warrant exception for seizing people is that because people can escape so easily, the police don't need a warrant except at home. She is at home, they need a warrant, they didn't get one. That's an unlawful seizure. It violates the Fourth Amendment. Don't just say it's an unlawful seizure. Point out it violates the Fourth Amendment, and point out that the Fourth Amendment is a follow to the State's Due Process Clause of the 14th Amendment. Okay. We're at line 14. He told her he was arresting her for the museum burglary and handcuffed to her. Okay, and that's where you talk about all this stuff. After Tech advised Sally of her Miranda rights, well, Tech did something right, at least. You don't interrogate people without giving them their Miranda rights. So after she immediately replied, "Hey, come on, I didn't do the museum job, Donna did." Well, she said, "I didn't do the museum job." Well, if she had made some incriminating statement, it would be suppressed for two reasons. It would be suppressed because it was the product of an unlawful seizure of her, unlawful arrest, and because of what we just talked about, and it was also she replied and said, "I didn't do the museum job. This was, it didn't violate Miranda. It just didn't." I thought we had a second reason here. So I guess all we have is the product of an unlawful seizure. And she says, "I didn't do the museum job, but this is not incriminating statement." She's saying somebody else did it. I didn't do it. So she was really not, if she had made an incriminating statement, you'd get it suppressed because of the product of an illegal seizure. But that's not incriminating. Then she says, line 16, "Donna did it." Well, it's still not incriminating Sally, so we got nothing to suppress. And by the way, Donna cannot assert Sally's constitutional rights. So Sally is now making statements against Donna, but you can't suppress them. Donna can't suppress them on the grounds that they violated Sally's constitutional rights. If they violated Donna's constitutional rights, then she might suppress them. Continuing, line 16. "She told me she broke in and took a drawing." Aha. Hearsay. And once again, she's saying, "Donna told me this," and Sally's rights have been violated. Donna's rights have not been violated. So Donna won't be able to suppress this as violating the Fourth Amendment. However, Donna can still say, "Hey, this is hearsay. Donna told me." And so that's going to be, so Donna told the cop, and now if the cop testifies, that'll be hearsay. Let's keep going. "Donna told me she broke in and took the drawing. She said she sold it in Switzerland." Okay, so all that stuff is hearsay, and we'll see if that becomes a problem later on. It's hearsay unless Donna takes the stand and says the same thing. But Donna told the cop, Tech, and if Tech takes the stand and says that, it's going to be hearsay. Next paragraph, line 19. "Based on Sally's information, the grand jury issued a subpoena ordering Donna to appear." Okay? Well, now when you present stuff to the grand jury, they can issue subpoenas, and they can issue subpoenas based on illegally obtained information at the grand jury. Okay? At the grand jury, the prosecuting attorney is trying to establish before this group of disinterested citizens who make up the grand jury that we, the state, have probable cause to believe that this person committed a crime, and therefore we want you to indict this person for a crime. And if the grand jury says, "Okay, we hereby indict them," then the prosecution can have them arrested and start a trial. And that's what grand juries do. Now, under the federal system, the only way you can start a prosecution for a federal crime is through a grand jury for a federal felony, not misdemeanors. Is through a grand jury. So that means that the federal prosecutor has to go before the grand jury and say, "Here's what we got. We think this constitutes probable cause." Grand jury says yes or no. Grand jury says yes, you can proceed. Now, when the prosecutor goes before the grand jury and makes this presentation, the prosecutor can offer hearsay, they can offer illegally obtained information, all that stuff can be presented to the grand jury. You don't have hearings there to decide whether or not the evidence is admissible. Now, of course, when you get to trial and the prosecutor tries to present that same information at trial, it might end up getting suppressed. But for the grand jury, it does not. You can bring it on. Also, don't forget that the person who is being indicted doesn't have a right to appear. They don't have any of that stuff. And the grand jury also, in order to get information about stuff, they can subpoena people and say, "You, so-and-so person, show up before the grand jury and answer some questions. Now, when these people show up before the grand jury, they can assert their Fifth Amendment, saying, I don't want to incriminate myself before the grand jury. And you recall that the grand jury has the right to give them immunity if they want to. There are two kinds of immunity. Actually, the prosecution grants them immunity, and the two kinds of immunity can be granted. I think it's the prosecution who grants the immunity, not the grand jury. The prosecution grants immunity, and the two kinds of immunity, there is transactional immunity and use immunity. Now, the transactional immunity means that if this person testifies that anything that they say about a particular transaction, pardon me, let's back up. The person is asked to testify about a particular transaction. You give them transactional immunity, you cannot prosecute them for that transaction, the one they testified about. On the other hand, if the jury merely gives use immunity, that means, if the prosecution gives use immunity, then the prosecution cannot use anything that was said to the grand jury. That's a more limited immunity. Use immunity, we won't use what you said. Transactional immunity, we won't prosecute you for the entire transaction. That's much broader and harder to get, of course. But so getting back to our problem here, the line 19, based on Sally's information, the grand jury issued a subpoena ordering Donna to appear. Well, she's got to show up. And they said, line 20, submit the fingerprinting. Well, the grand jury can require that she submit the fingerprinting. Now, you can't require that people testify against themselves. You can't do that unless you're going to give them either use immunity or transactional immunity. You can't require them to give testimony that would tend to incriminate themselves. But you can require that the person show up at the grand jury and get fingerprinted. Fingerprinted is not testimony. You can require that the person bring certain records. Well, these records are not testimony. They may be business records or that sort of stuff. Show up and bring the records. That's not testifying against yourself. And so they ask her also to produce her passport. That's not testifying against herself. So the grand jury is within its authority to require the fingerprinting and the passport, and it does not violate the Fifth Amendment against self-incrimination. Line 20. After the court denied Donna's motion to quash, okay? After the court denied, this means that Donna, if the grand jury says to Donna, come to court and do certain things, and Donna says, I don't think I have to do that, she can go to a court, a regular court, and try to get it quashed. And if she can make a good enough argument, she can get it quashed, but she's not likely to succeed. And here she did not succeed. After the court denied Donna's motion to quash the subpoena and ordered her to comply, she submitted to fingerprinting, okay, and turned over her passport. Great, no problem. Her fingerprints were found to match those in the museum. Oh my goodness, she's in trouble. Her passport bore a date stamp showing that the holder had entered Switzerland 2 days after the museum burglary. Oh my goodness, she is in trouble. If she's out on bail, she probably needs to leave the country. Line 25. Sally has left town and cannot be located. So we've got some hearsay from Sally, and if Chet tries to testify to what Sally said, it's going to be hearsay. And normally, of course, Sally could take the stand and testify, and if Sally testifies to what Donna said to her, that would be an admission from Donna. And admissions, of course, in state law, they are an exception to the hearsay rule, and under the federal rules, admissions are by statute declared not even to be hearsay at 801 D1C, or 801 D1. And so admissions are something not hearsay. So if Sally were testifying, Donna's admission would come in. But Sally is gone. She's not testifying. Let's keep going. Line 25. Sally has left town and cannot be located. Donna has been charged with burglary and theft. Okay, so we're going to Donna's trial. Line 27. Donna moves to exclude the following evidence. Line 29. Item 1. Sally's statement to Tech, which she claims, 1, is hearsay, the admission of which would violate her rights under the Sixth Amendment. Well, now wait a minute here. The statement that Sally's statement to Tech, if Tech is going to testify, that is hearsay. That is hearsay. But the Sixth Amendment is the right to counsel and the right to confront witnesses. Well, her right to Donna has a right to counsel, but her right to counsel has to do with Donna being interrogated without her counsel being there after she's been charged. And once a person has been charged, then the Sixth Amendment says a couple of things. Let's back up for a second. The Sixth Amendment says four things that are important for our purposes. Let's talk about the Sixth Amendment for a moment. Sixth Amendment says, number 1, person is entitled to a speedy trial. And to decide whether or not the trial has been sufficiently speedy, the courts look at several factors. Number 1, how long was the delay to the speedy trial? Number 2, what were the reasons for the delay? Number 3, was the defendant prejudiced by the delay? And number 4, did the defendant make an effort to get a speedy trial, object to the delays? So in deciding whether or not the right to a speedy trial has been violated, courts will look at those factors. How long was the delay? What was the reason for the delay? Was the defendant prejudiced by the delay? And did the defendant try to get the speedy trial? Now, remember, a lot of times defendants don't object to delays because delays usually work in criminal processes. They usually work in favor of the defendant. They prefer delays because witnesses get lost and they leave town and they die and all kinds of things happening. Evidence disappears for some reason. And so defendants like delays. So if the defendant's going to complain about the delay, the defendant's going to have to show, well, I tried to get a trial and I just couldn't, they wouldn't do it. So the four things under the Sixth Amendment: number 1, the right to speedy trial. We just talked about that. Number 2, right to a trial by one's peers. The right to trial by one's peers. And this has to do with the jury selection process. The jury selection process requires basically 2 things. One is that the people who make up the jury are selected more or less randomly from the local population. This means you can use other things, such as the telephone directory. Now, not everybody has a telephone. We realize that may exclude some people. You can use the voter registration list. Not everybody votes. That will exclude some. But it's a pretty fairly random selection of people if you did something like that. You could even use driver's license numbers and choose it that way if you want. People who live locally. So number 1, you have to have a panel of people from whom you select. That is a random selection of people randomly chosen from the community. That's of your peers. And secondly, once the person has been selected to be a juror, and they are now going to be voir dire, they're going to be questioned either by the judge or by the 2 lawyers, depending on how the jurisdiction wants to do it. And now the lawyers can exclude people for cause if they got this far. For example, if They can establish that someone would be biased against this defendant because this is a defendant's spouse, it's a defendant's close relative, the defendant's close friend. Someone is the husband or wife of a police officer. Someone is related to the prosecutor or defense. People who have reason that they might be biased, you can exclude those people for cause. And then finally, of the people who are selected and not eliminated for cause, the prosecution and or defense would have a certain number of preemptory challenges, where they can just dismiss somebody because they don't like the way they comb their hair. You don't have to give a reason. One thing you have to be careful about this is that there are these cases where the prosecution particularly will, and it could be the defense too, but all the cases now are prosecution, eliminating people for under preemptory challenges for illegal reasons. They eliminated all the blacks on the jury because there's a black defendant. Or maybe they eliminated all the blacks on the jury for any defendant because they don't want to vote guilty so easily. They eliminated all the women on the jury because this was a rape case. And so forth. So if the prosecution, if you can make a credible claim, not to prove it, if you can make a credible claim, enough so that you got some evidence to support it, enough that a rational person could believe that it happened, you can show that the prosecution has a pattern of eliminating certain protected classes from the jury. If you show that, credible evidence of that, then the burden shifts to the prosecution to prove I didn't do that. Okay? And they got to come up with the evidence that they didn't do it. So, jury selection. So, on the Sixth Amendment, right to trial by your peers, right to a speedy trial, right to assistance of counsel. That means the assistance of effective counsel. It also means the assistance of counsel at all critical stages of the proceedings, of the criminal proceedings. The right to assistance of counsel. Now remember that in the old days when the Constitution was written, a lot of people just defended themselves. They got up and told their story the way they thought the rest of the jury should understand it. So you don't have to have a lawyer. You have the right to assistance of counsel, but you also have the right to defend yourself unless you're totally crazy. You don't have to have legal training. You don't have to be a college graduate, any of that stuff. You don't even have to speak English. You got an interpreter. So you have a right to defend yourself if you want to. That's a constitutional right. But you also have a right to the assistance of counsel if you want it. And under this right to assistance of counsel, you certainly have a right to assistance of counsel at the trial. Well, what about at other proceedings other than the trial? Suppose you're going to be interrogated by the police. Do you have a right to have your lawyer there? Well, the deal is as follows, that if you're going to be interrogated by the police before the court system gets into the act, if you're going to be interrogated by the police before the court system gets into the act, the Fifth Amendment, the Miranda rights, you got to give the person Miranda rights and say, you have a right to the assistance of counsel, you have a right to remain silent. If you can't afford a lawyer, we'll appoint one for you, all that stuff under the Miranda rights. So if the police are going to interrogate before the person before the court system gets involved, then you got to give them Miranda rights. Now, so this means, for example, if the police arrest somebody on the street and they don't want to ask them any questions, they're just going to arrest the person, they don't have to give any Miranda rights. They take them downtown, they lock them up. No Miranda rights. They're not interrogating. But if they decide to interrogate, now they got to give them Miranda rights. When they give them Miranda rights, you got to watch for a couple of things. One is the Miranda rights. You got a couple of important separate rights in there. One is the right to remain silent, and the other is the right to assistance of counsel. If you give the person a Miranda right, and the person says, I want to remain silent, or I don't want to talk to you, I have nothing to say to you, go away, I don't want to talk to you. They have asserted their right to remain silent, but they have not asserted their right to counsel. On the other hand, if the person says, I want to see my lawyer, or get my lawyer, I have nothing to say to you until my lawyer is here. If somehow, now if they say until my probation officer is here, that doesn't count. And until my relatives are here, that doesn't count. It's got to be their lawyer. Okay, so I have a person that says, I don't want to talk to you until my lawyer gets here. Well, now though asserting those two rights has a different effect. The right to remain silent and the right to assistance of counsel. And as soon as we come back from our break, we want to talk about those two rights, the right to remain silent, the right to assistance of counsel. Then we want to continue with the rights under the Sixth Amendment. Remember, we're talking about, let's put that on the board here, just to be sure you're clear what they are. We're talking about the rights under the Sixth Amendment, and we say there are four of them that you have. One's the right to a jury of your peers. The other one is the right to assistance of the right to a speedy trial. Next is, remember, there are four things you looked at here. The right to a assistance of counsel. And finally, is going to be the, which one am I missing here? Peers, speedy trial, assistance of counsel. I think we got them all. Okay. I said four, you said three. So we are talking about this. When we come back from our break, we'll pick it up here and continue from there. Let's take 10.